The first pain point with Innovator Founder Visa applications is the co-founders. So basically, don't have a co-founder if you're applying under the Innovator Founder Visa. It leads to all kinds of problems. Now, there's a bit of a paradox here in that if you're applying for an endorsement, then having co-founders actually helps. It's just that if you get through and get the endorsement, then good luck getting through the home office stage. They will give you a really hard time. Now, what's driving this? What's driving this is this hypervigilance by the Home Office about the risk of one person piggybacking off someone else's business idea for immigration purposes, as opposed to what? Business purposes. So in other words, they focus in on the one area which I thought would be least problematic 3 years ago when they released this visa route, which is day-to-day involvement. What they don't want is a passive investor, and wherever a co-founder appears on the scene, they think there's a risk that the applicant is a passive investor, and this is all being arranged for them by the co-founder. Now, if you have a traditional CEO and CTO split, and you're a business person, maybe an MBA, and you're applying you're applying as CEO, then that's going to be less problematic than if you are outsourcing it to a digital agency, if you're outsourcing the build. So if you get endorsed, the first question that the Home Office will ask, and they will ask questions in pretty much every application now, first question they'll ask is, who's building this? Who's building this thing? Whether it's hardware or software, they will ask who's building it. And if you're not building it, but you're outsourcing it to a digital agency, then that's, I wouldn't say it's guaranteed a refusal, but it's probably going to be refused. If you absolutely have to have a co-founder, then you would have them as CTO. So your CEO, their CTO, and the division between you is very clear. Ideally, though, the CTO themselves would not be applying for a visa themselves. So if you really want to mitigate that risk, you absolutely have to have a co-founder. Then you'd have CTO, and that person is not applying for a visa. Of course, the immigration rules allow you to apply as co-founders. I've actually assisted many people as co-founders applying, so co-founder teams. In fact, I think I've mentioned before that the maximum number of co-founders I've had before was 5 people, all applying as co-founders together, and that got through. But I'm talking about what is the optimal approach, and the optimal approach now, in mid 2024, is to apply as single, ideally technical founder. Now, in the Global Talent Visa, there's a specific business stream and there's a technical stream. And it's almost developing like that with the Innovator Founder Visa, in that if you are a technical founder, let's say your original degree was in computer science, for example, and you're saying, I'm going to build this myself, then you might have a bit of pushback at the endorsement stage, like, hang on, is it realistic that you're going to be doing this yourself? But at the Home Office stage, in other words, that's all that matters, right? Getting the visa. At the Home Office stage, they may not even interview you. I said that they're asking questions in all cases. I have had at least 2 recent applicants who weren't asked any questions, and they were technical single founders. It's not that they were saying that they wouldn't have any help with their business, but basically they would be building it or driving the development of the product. Now, a little nuance in here, please, which is that for business founders, there's a lot of no-code tools or low-code tools. So I have had applicants who have been business stream, if you like, who didn't have a computer science degree, etc., didn't have any coding competence, but who were saying that they would be building it on a no-code or low-code tool and had already made steps towards executing that. And through a lot of these tools, you can actually have some assistance as part of the proposition. So that seems to be a pathway of less resistance if you are applying as a pure business founder with no coding competence in respect of software. The same would apply if you're a non-STEM person, non-scientist, non-engineer, pure business founder applying. If you didn't have any of those STEM skills and you were applying in respect of hardware, then you'd meet similar levels of potential resistance, or at least a greater degree of scrutiny with a greater potential for refusal. So the second point, that was the first point, co-founders. The second pain point is technical competence, which I've mentioned. I mean, it's part of this the same point. The third pain point is innovation and patentability. Now, it used to be the case that it was much easier to get applications over the line on innovation, but the threshold has gone up and up and up. Now, most recently, the Home Office has even threatened the endorsing bodies. Again, there's 4 of them, right? So the 3 non-government endorsing bodies, with saying that, look, we're considering effectively sanctioning you for a case where you endorse and we refuse. Because with a couple of the endorsing bodies, the refusal rates are very high, right? And often more than half of the applicants who are endorsed are being refused. So this annoys the Home Office. But in fact, the Home Office really ought not, under the guidance, to be reassessing innovation unless there's more information made available to them than was made available to the endorsing body. But they can approach that by simply asking questions and I suppose assuming that the responses haven't been also elicited by the endorsing bodies. So in any event, they are second guessing the endorsement in a way that they do not with, say, Tech Nation. If you're applying under the Global Talent Visa, the Home Office say, look, we don't even want to see the documents. So they don't second guess endorsing bodies in that context, but they do in connection with the Innovator Founder applications. So when it comes down to innovation, there's greater pressure on the endorsing bodies now than there's ever been. But and I would say now, because it was really the previous government that was pushing the very much sort of anti-immigration angle, or that was trying to cut back on numbers. The current government at the moment hasn't made any major policy changes, and really it's probably the last area where they'd be looking at making major reforms in terms of social reform generally in the UK. So there haven't been any major changes since the last government was pushing it. Now, the pressure was on really from the last government rather than the current government. So it may have lessened slightly, or at least not reached greater levels. But that was the latest thing, basically, with the endorsing body. So they feel certainly under pressure to refuse more applications. And I don't think that's particularly changed under the current government, although there hasn't been any additional pressure put on them, to my knowledge. So they're still in a state where the endorsing bodies are applying a much higher standard on innovation than they did historically. So what can you do about that? Well, I mentioned patentability as one pathway, because if you've actually applied for a patent, of course can take many years to go through, but if you've applied for a patent, then that means there was sufficient material and a sufficient patent search for you to put together an application, a valid application that's pending, right? No decision has been made on it, could still be refused, but there was sufficient material for you to make the application. Then that in itself is significant. And if you can get as far as making a patent application, then it's difficult for an endorsing body to disagree on innovation. And if an attorney has signed it off as innovative and as patentable as part of that process, again, more difficult for them to take a point on that. Now, they do look more generally at the market and what's going on in the market and the extent to which that's saturated. And one of the endorsing bodies is taking a really unimpressive approach to this, I must say, which is you can tell from refusal letters, people approach me where they've done the application themselves and they've been refused, and you can see that it's been AI generated, right? The refusal grounds. You can just easily spot ChatGPT. So in that situation, you have some people, putting together ChatGPT generated applications, and then they're going over to the endorsing body, which is then sending back a ChatGPT generated refusal. But in any event, they are looking, or their AI is looking at how the product is placed within the market and how saturated it is. And if they will Google what you're doing and see what the results show. So that's part of it. But really the more substantive point is it patentable? So if you can address that point, then it's easier to get it over the line. And the other area, just for completeness, is market validation. So even if you're self-reporting that people are interested, then you should give some details and particulars on that. So in summary, 3 pain points for innovative founder applicants: co-founders, technical competence and outsourcing, And number 3, innovation and patentability. I hope that's helpful. If you do want to speak with me, I have a consultation service. You can get me on the link below and on my website. Feel free to get in touch. I'd be very pleased to help you. Good luck with your application, and bye for now.